And I just want to say that the American Embassy is really honored that on the prestigious civil service exam, there is a portion dedicated to US history, politics, and culture. And I think that's really a reflection of the importance of the US-Pakistan relationship. And certainly it's very important to the United States. The US Embassy is really pleased to partner with the American Institute of Pakistan Studies. They've been a great partner in this program. They have lined up a stellar list of speakers, and we're really looking forward to each of the 6 sessions, and I hope you are as well. Some of our top academics from several universities in the United States. I'd really like to take this opportunity to recognize that both of our countries have lost many cherished citizens to COVID-19, and both our countries are really struggling to convince all of our citizens to do everything possible to prevent the spread of the disease. So I want to encourage all of you to encourage your family and friends and coworkers to please, maintain social distancing of 6 feet, to use face coverings when you have to be in public, and also to wash your hands frequently. I just, wish all the best to both of our countries that we can overcome this and not lose so many of our citizens. And finally, just thank you to everyone for your participation. I've been looking forward to this day and very excited to hear the presentations and especially to hear your questions. So now I will turn it over to Dr. Farhat Haq, the Executive Director of AIPS.
Thank you very much, Ms. Sorenski. My name is Farhat Haq, and I will be moderating these sessions. So let me introduce our first speaker. We're very excited to have Dr. Eric Casper as our first speaker to talk to you about perhaps one of the most fundamental things about US, and that is its Constitution. Dr. Eric Casper is the best person to talk to us about that. He's an associate professor of political science at University of Wisconsin-Eau Claire and a director of Center for Constitutional Studies. He holds a PhD in political science from University of Wisconsin-Madison and a JD in law from University of Wisconsin-Madison, both from Wisconsin-Madison. His teaching interests are in US constitutional law, judicial politics, political philosophy, jurisprudence, and American politics. And he has also researched in these areas and have published widely. So we're very excited to have him. Over to you, Professor Casper. We look forward to your presentation.
All right, well, thank you. And I'd like to thank both the American Institute of Pakistan Studies as well as the US Embassy in Pakistan for inviting me here to do this talk today. What I'm gonna do is, hopefully I can get this to work, to share my screen. Looks like it's working. And so what I want to do here is work through, as the title here suggests, both the origins of the US Constitution as well as its development over the 2+ centuries since it was adopted. And so about half my presentation will dive into how the US Constitution came about and what the US Constitution looked like originally. And then about half my presentation will look at amendments that have subsequently been ratified, as well as US Supreme Court decisions interpreting what that document looks like. So as far as how we got the Constitution in the United States, it's important to understand where the country was at the time of the American independence movement. As there was a building up to the point of independence, you had an assemblage under the Continental Congress, which had delegates from the various colonies in what eventually became the United States, congregating to be able to discuss their concerns, to be able to basically write resolutions about what they thought wasn't being done properly by the British King or by the Parliament. During that period, as the movement towards American independence grows, you have the Declaration of Independence coming into effect and being put forth in 1776. And you have individual states being born in the US, writing their own state constitutions. But at a national level, there was nothing formally in place at first, and the Continental Congress kind of became somewhat of a de facto government. But clearly, the founders of the country knew that something more formal needed to be put in place. So beginning in 1777, Continental Congress passes the Articles of Confederation. And so the Articles of Confederation really would become America's first constitution. But as I'll talk about shortly, when we talk about the Constitution in the US, we're not really talking about the Articles of Confederation. But that really was the first governing document over the country. Now, the Articles of Confederation required the unanimous consent of each state in order to be put into effect. So even though the Articles of Confederation were proposed in 1777, they didn't actually get ratified and go into effect until 4 years later in 1781, when they had that approval from the states. Now, as far as what the Articles of Confederation looked like, the Constitution, if you will, before the US Constitution, it was, compared to what we have today in the US, a very streamlined a system of government. There was a Confederation Congress, a Confederation National Legislature, if you will, but there was no separate presidency or no separate executive branch of government. There was no separate branch of national courts. And so it really was, the national government really was just this Confederation Congress. Now, over the years that the Articles of Confederation were in effect, though, there were some problems that developed. Even as the country was concluding the Revolutionary War, formally and fully breaking free from the British, there were concerns among many about how the Articles of Confederation were operating. The Articles of Confederation basically put a lot of authority at the state level, but provided relatively little in terms of power at the national level. And so, for instance, states had the ability to decide whether or not they wanted to provide revenue to the Confederation Congress. The Confederation Congress didn't have the direct power to raise and collect taxes. Instead, they had to rely on the states to provide them with financing. The Confederation Congress did not have the power to regulate interstate commerce. And so you had low-level trade wars developing, trade barriers being put in place amongst the states, hindering the growth of a national economy. You have states with the power to print their own currency. And so there were currency exchange issues that arose because there was no national currency in the US under the Articles of Confederation. And there were real concerns about the ability of the national government to enforce treaties because of the fact that the real power was at the state level. Now, all of these problems on the Articles might have been something that could be overcome, except there was a development that occurred in 1786 going to 1787, which really became one of the key catalysts for the development of what we now call the US Constitution. And that was an event known as Shays' Rebellion. This occurred in the state of Massachusetts, where Daniel Shays was the leader of a rebellion of a number of Revolutionary War veterans who were farmers, who were having their farms foreclosed upon. It was during a period when there was an economic recession. A lot of farmers were having trouble being able to pay their mortgages. And so Daniel Shays led a group of these farmers to local courthouses in rural Massachusetts to basically keep the courthouses from being able to open. Because if the courthouses couldn't open, then the foreclosures on their homes and their farms couldn't be processed. So Massachusetts is having problems being able to put down this rebellion. They call upon the Confederation Congress to help, to send some sort of assistance in terms of military support. The Confederation Congress is unable to respond in any effective way. And it really shows some of the just lack of efficiencies and inability to keep order that were some of the problems under the Articles of Confederation. So you have the plan then amongst members of the Confederation Congress and amongst other civic leaders to put together a convention and to be able to address some of these concerns. And one of the more interesting aspects of that, and how you can see how a plan to go in one direction can maybe take you in a different direction, the convention that was set for 1787 was a convention for the sole purpose of revising the Articles of Confederation. But very quickly, once the convention began, the delegates at that convention scrapped that plan entirely. They decided they would write an entire new document. And they ultimately put together a document that would replace the Articles of Confederation as opposed to just revising them, okay? So in the US Constitutional Convention, they begin meeting in May of 1787. They meet all the way until mid-September of 1787, meeting 6 days a week in Philadelphia. And there were representatives from all across the country, and these representatives came representing a lot of different interests, from northern states and southern states, from states that were large in terms of population, those that were small in terms of population. And what would eventually become the US Constitution has sometimes been known colloquially as a bundle of compromises, because these different interests would put forth competing plans about how to do various parts of the government, what the government should look like. And ultimately, they came together and compromised on a number of occasions. One of the most noteworthy of these compromises came out of how to resolve a difference between what was known as the Virginia Plan and the New Jersey Plan. The Virginia Plan was something, a set of ideas about how the US government should look that was put together by the delegates from the state of Virginia. And the state of Virginia was the most populous state at the time. And so, among other things, what the Virginia Plan did is it said that the national legislature should be based on population. In other words, the more people who lived in a state, the larger their number of representatives in the national legislature should be. Less populous states at the time, including New Jersey, which did not have a large population in 1787, they had major concerns with the Virginia Plan. And the New Jersey Plan was put forward as a counter-proposal at the convention to say that instead the national legislature should allow each state to have an equal number of representatives. The New Jersey and other small states said that if we base the national legislature on population, then that will mean the more populous states will be able to control what the new government does, and the less populous states will have no real voice. And so, as you can imagine, those are two very different plans. They had different supporters who were unwilling to budge for a significant period of time during the convention. But ultimately, the way that this was resolved is what's been known as the Great Compromise, which is we'll just do both of these plans in effect. And so what happened under the Great Compromise is the United States Congress would be comprised of two houses or two chambers, the House of Representatives, which is based on population, and the Senate, which gives each state 2 senators. So you have both a part of the legislature that's based on population and a part that is based on each state having an equal voice. And that was a compromise that did enough to be able to make both sides of that debate happy enough to be able to agree to sign on to the document. There are a lot of these types of compromises that occurred at the Constitutional Convention. Not all of them, though, carry with them this sense of, boy, they made it work and everyone should be proud of what happened. Of course, one of the parts of the American story is slavery. And slavery was in 1787 still legal in several states. And there was a deep division amongst the delegates at the convention, how to handle questions about slavery. One of those compromises dealing with slavery is what's come to be known as the 3/5 compromise. And this compromise arose because of a difference between not the more populous states and the less populous states, but a difference between northern states where slavery had been abolished and southern states where slavery was still very much active and very much a part of the southern economy. So once it was established under the Great Compromise that there would be at least one chamber of Congress based on population, the Southern delegates put forth the proposal that when counting population, persons who were enslaved at the time should be counted as a part of that population. Some of the Northern delegates, though, cried foul at this, and they said, well, if you're treating persons who are enslaved as property, how is it fair to then count those persons towards your population to therefore inflate the size of your population? But another way, the Northern delegates were saying, you're not going to allow these persons the rights to freedom or the right to even vote. Why is it the case that they should be counted in terms of what your population numbers are, and therefore giving Southern states more representatives in the House? And so the way that this was resolved was, as I noted earlier, it's been called the 3/5 compromise. That for every 5 persons who were enslaved, they would count as 3 persons for measuring population when it comes to deciding how many representatives there would be in the House of Representatives. Now this is one of these cases where I think there's a quote from Thomas Jefferson that might be apt here, where he talks about how some people like to ascribe this almost deity-like quality to those who were at the U.S. Constitutional Convention. But he says, well, you know, I was a part of that generation, he said years later, and I know those who were involved at the Constitutional Convention. But he went on to say that I know that laws and institutions must go hand in hand with the progress of the human mind. As that becomes more developed, more enlightened, and as new discoveries are made, new truth disclosed, then the Constitution should keep up with the change of circumstances. In other words, institutions must advance and keep pace with the times as well. It's a long way of saying that even though this particular compromise was made, it shows us that under the Constitution, compromises that are made that we don't look back with reverence and fondness can be changed. And as I'll talk about later, ultimately, slavery is abolished under the U.S. Constitution. The right to vote is promoted in a much greater degree years later. And the U.S. Constitution, because of the ability to amend it, it's able to change as we as a society change as well. Also of note here on the screen, I have James Madison pictured. James Madison was one of the most influential members of the Constitutional Convention. He was one of the most active speakers at the convention, a proponent of the Virginia Plan, a proponent of a lot of these compromises. He was a major part of the ratification debate, because even after the convention passed this document, it didn't go into effect until it was ratified by a sufficient number of states, and that took several months. Madison was actually a very key person in terms of convincing voters in 2 of the most populous states, his home state of Virginia and the state of New York, to ratify the document. And as we'll talk about later, Madison also becomes later on the author of the U.S. Bill of Rights, which becomes a very important part of understanding the U.S. Constitution as well. So again, that's kind of historically how we got from point A to point B in terms of how we got a constitution. Now, in terms of the thought behind the Constitution, some of the very big principles that are in place that we could look at here get to these questions of what the government is supposed to look like and why. So the U.S. government under the Constitution is much more significantly empowered than it was under the Articles of Confederation, at least at the national level. A lot more power that was placed there. In addition, there is this separation of powers that is put in place. Remember, under the Articles of Confederation, there is basically one branch of government at the national level. It's a Confederation Congress. Here now we have a legislative branch that is distinct from an executive branch and a judicial branch at the national level. And as we'll see in more detail, each of these branches has these different powers to check each other and to be able to balance the power of each other, so no one part of the government can exercise too much power without being stopped at a certain point by one of the other branches. Even under this empowerment, we have still in place a system of federalism. In other words, there is a significant amount of power placed at the national level, but there's also a significant amount of power still that resides at the state level. And then along with all this, there are various provisions, some in the original Constitution, but more so in the Bill of Rights, that protect individual liberties. And then even later on, some of the later amendments that protect other rights, particularly due process of law, equal protection of the law, and the right to vote. And how do we get to these ideas that are behind the US Constitution? Well, what we find is that some of the theorists who were being read and studied by some of these key delegates, like for instance, James Madison, were putting forth these ideas in the text that they had written. Some of the key ones I list here on the slide. Thomas Hobbes, a 17th century English philosopher, who talked about the need to empower government so that the government can protect people both from threats from abroad, in terms of different types of military invasions, as well as a government powerful enough to be able to create an orderly society internally. So this notion of putting more power at the national level of government is in some ways a reflection of Thomas Hobbes and his philosophy and his influence over the American founders. Perhaps even more of an influence was John Locke, another English philosopher who wrote very famously in his work, Two Treatises of Government, about the need to separate legislative and executive power so that you have two different sets of hands who could limit the power of the other one in order to protect, as a way at least, to protect basic human freedoms. And that idea then comes into play in terms of the notion of a separation of powers as well as protecting individual rights. And then we have the French philosopher Montesquieu, who his major work, A Spirit of the Laws, was an 18th century book that was still very much in vogue amongst the founding generation when they were debating and writing the Constitution. And Montesquieu takes Locke's idea of a separation of powers a little bit farther. While Locke said that we need to separate legislative and executive power, Montesquieu said we also need to separate executive and judicial power. Locke kind of shoehorned judicial power into executive power. Montesquieu says that we need to separate that out. We need to have three different parts of the government exercising three different types of power. And Montesquieu was also a proponent of federalism, basically saying that there are certain things that need to be done and are done best at the state level. Other things that could be carried out better at a national level of government, particularly things like national defense and international diplomacy and things like that. And so again, these ideas that we're going to see here as we go along do not come out of thin air. There's a philosophical background in terms of what was being debated and what was being read by the American founding generation. Now, if we start to look specifically at the structure of the US Constitution, what we find is, first of all, some significant differences between what is in the Articles of Confederation and what is in the Constitution as it's ratified and goes into effect in 1788. As I noted, we have this increase in power of the national government. What does that mean more specifically? Well, the national government is given the power, and Congress in particular is given the power under the Constitution to regulate interstate commerce and to have the power over finance in terms of taxing, in terms of spending ability. We have a national court system that is put into place, which again wasn't something that existed under the Articles of Confederation. And as we'll see, this is a branch that has the authoritative power to say what the law means. And then we have a strong executive branch. that is built into the US Constitution, something that is not only separate from the Congress, but also something that has a lot of power in its own right. Now, one of the other key things to understanding the American founding generation is while they wanted a representative form of government, they didn't want too much democracy. A lot of the members of the American founding generation, those at the Constitutional Convention, they saw a fully democratic government as something to be feared. It's why they put in place this system, for instance, of checks and balances. So each branch has this ability to be able to check and to balance the others. Congress has the power to pass laws, but the president has the power to veto that legislation. The president can appoint members of the Supreme Court and other federal judges, but the Senate has the ability to reject those appointments. The US Supreme Court has the ability to strike down laws if they find them to be unconstitutional. But the budgets of the court, for instance, are under the control of Congress. And so you have powers that each part of the federal government is able to exercise, but they are limited by what the other branches of government can do. In addition, that great compromise that we talked about earlier, saying that we're going to have a House and a Senate, and each one will draw representation in a different way. In addition to just compromising over that issue of how do we have representation, it also, as creating a bicameral legislature, means that it would make it basically twice as hard to pass legislation, because in order to pass a law, it has to go through not one, but two different chambers in the same form. And so that limits what can be done as well. And it limits what the majority of representatives, what the majority of people might want. And then we have the Electoral College. And we'll talk about this more as we go along, but the voters in the United States do not directly elect our president and our vice president. Instead, what we have is an Electoral College. We elect a group of people who then elect the president or the vice president. Now, due to changes that have taken place in each state, those who are named to be a part of the Electoral College are typically expected to vote the way that the majority or the plurality of voters in their state want them to vote for president. But that hasn't always been the case. And even today, there are some members of the Electoral College who vote for someone else, even if it's not who the largest group of voters in their state want them to vote for. And then, again, as I noted earlier, we have these different ways in which government abuse can be limited in terms of separating power, so no one part of the government exercises all the power, dividing that power between states and a national government in the system of federalism, and then having this separate Bill of Rights that is ratified in 1791. So you have, again, these different ways that the US Constitution looks compared to the Articles of Confederation right off the bat. Now, moving through the document, there's a preamble that talks about general principles to be promoted by the US Constitution. Things like promoting the general welfare and protecting the nation from external threats, promoting liberty, these sorts of things. Kind of a general state of principles, a mission statement, if you will, right at the beginning of the Constitution. But from there, the Constitution moves into these different articles. And each article kind of has a different theme to it. Article 1 is primarily about the legislative branch, about Congress. And the House of Representatives has always been directly elected every 2 years. It's the part of Congress that's closest to the people. While the Senate, members of the Senate have much longer terms of 6 years. Originally, they were represented, or they were representative, I should say, of state legislatures. They were appointed by state legislatures in each state. But as a movement towards having a more representative system of government took place in the late 19th century, early 20th century, beginning in 1913, senators are directly elected. Senators still represent typically a much larger constituency than members of the House of Representatives, but they are now directly elected by the voters as well. And Congress has all these powers that I talked about earlier, both express powers that are specifically limited in the Constitution, specifically written in the Constitution in terms of the power to tax and spend and to regulate interstate commerce and that sort of thing, but also implied powers. There's a clause in the Constitution, it's called the Necessary and Proper Clause, that says that Congress, in addition to the powers that are listed, can exercise powers that are necessary and proper to carry into effect those foregoing powers. Now, when you look at Article 2, that's primarily about the executive branch or the president. And as I noted earlier, this creates a president who is independent from the powers of Congress. Unlike a parliamentary system where the head of the executive branch is in fact a member of a parliament, here in the US, the president is completely separate from Congress, is separately elected, and has a separate set of powers. And though that indirect election by the Electoral College is for 4-year terms, and the powers of the president are significant in their own right. The powers to appoint various federal officials, the power to appoint ambassadors, the power to veto legislation, the power to act as commander-in-chief of the US military are all different powers that are vested in the presidency. And then Article 3 is all about the judicial branch. It creates the US Supreme Court, sometimes known as SCOTUS, Supreme Court of the United States. Article 3 allows Congress to create other federal courts. The only federal court that's required by the Constitution is actually the Supreme Court. And Congress has seen fit to create a lot of other federal judgeships. And as I alluded to earlier, members of the federal courts and the Supreme Court included, they're nominated by the president, but then they are confirmed or rejected by the Senate. And unlike the time-limited terms of members of the House and the Senate and of the president, federal court judges, Article 3 federal court judges have lifetime tenure. And that's meant to insulate them and to give them a greater level of independence so that their decisions are not dependent upon the other branches of government or upon voters, that they can make the decisions that they see as fit. The Supreme Court in particular, it's important, has this power of judicial review, which I'll get into more later, gives them the ability to say that an act of Congress or something that's done by the president or even a state government is unconstitutional and therefore cannot be enforced. And then we have to kind of round out the articles. Articles 4 and 6 are more about questions of national unity and power, as well as federalism. Things like in Article 4, the full faith and credit clause that says that states have to respect the judicial decisions and official acts of other states, or the guarantee clause in Article 4 that says each state is supposed to have a representative form of government. And Article 6 includes the supremacy clause. The supremacy clause says that a valid federal law or a treaty, and certainly the US Constitution, is supreme over any state law to the contrary. Article 5 shows us how the Constitution can be amended. That it basically is a two-step process. In order to change the Constitution, there's a proposal that has to pass at the national level, but then it has to be ratified by 3/4 of the states before it becomes part of the Constitution. And Article 7 explained what was required to ratify the Constitution. And basically what it boils down to is 9 of the 13 states at the time had to ratify the Constitution for it to go into effect. So then we look at everything that's come after the original Constitution. The big piece here is the United States Bill of Rights. And this places a limit on federal government powers in a few different respects. There are various individual liberties and rights that are protected. The First Amendment protects things like the freedom of religion, the freedom of speech, freedom of the press. Second Amendment protects the right to keep and bear arms. The Third Amendment protects against having soldiers quartered in one's home. The Seventh Amendment protects the right to a jury trial in civil cases. The Ninth Amendment becomes kind of a catch-all that says other rights, even if they're not listed, are still retained. Then there's a whole set of rights focusing mostly on the rights of the criminally accused. The Fourth Amendment protects against unreasonable searches and seizures. The Fifth Amendment protects against the right against self-incrimination. Sixth Amendment protects the right to an attorney in criminal cases and protects the right to a jury trial in criminal cases. And the Eighth Amendment protects against cruel and unusual punishment. And rounding out the Bill of Rights was the 10th Amendment, which said that the states retain certain powers that are reserved for them if a power isn't delegated to the federal government and it's not denied to the states, and it's reserved for the states as a power. States keep those powers. And so that really rounds out what the original founding period put in place as far as the Constitution, but we've had a number of other amendments since then. Perhaps the biggest moment in terms of US constitutional change was right at the end of the US Civil War, where we have 3 amendments that really fundamentally change what the US Constitution looks like. The 13th Amendment abolishes slavery. The 14th Amendment defines citizenship as those who are born or naturalized in the United States. The 14th Amendment also protects rights to due process and equality. And then the 15th Amendment says the right to vote cannot be denied based on race. And so you really have this shift in terms of promoting equality and shifting powers from the states to the national level of government during this period right after the Civil War from 1865 to 1870. But there have been lots of other amendments as well, and I can categorize them here in a few different ways. One is amendments that have expanded the electorate. In addition to the 15th Amendment in 1870, we have the 19th Amendment extending the right to vote to women in 1920. We have the 23rd Amendment extending voting rights for the presidency and the vice presidency to residents of the District of Columbia, which is not a state, but they now have the right to vote for president beginning in the 1960s. The 24th Amendment prohibits poll taxes. This was something that could occur up until the mid-1960s, where one could be charged a fee in order to vote. And that's now not permitted under the Constitution. And the 26th Amendment in 1971 said that the voting age would be set to 18. The de facto position before then had been the age of 21. In addition, we have changes to how the federal government looks in terms of what these offices look like and how these members of Congress or the president get into office. The 12th Amendment created a separate ballot for the president and the vice president. Up until that point, whoever, basically people would run for the presidency. Whoever got the most votes would be president. Whoever got the second most votes would be vice president. But the development of political parties made that very difficult. And so now we have presidents and vice presidents who run on partisan tickets. 17th Amendment, as I noted earlier, provides for the direct election of senators. The 20th Amendment shortens the period between elections and when those who are elected take office. It used to be a longer lame duck period, as it was called, for members of Congress and the president. The 22nd Amendment generally limits the president to 2 terms in office. The president can't continue serving again and again. And the 25th Amendment puts in place procedures for presidential succession and even removal under certain circumstances. And then we have various amendments that get to expanding or limiting government power. In addition to the 13th and 14th Amendment, which I noted earlier, we have the 11th Amendment, which puts certain limits on federal court jurisdiction if someone is trying to sue another state. We have the 16th Amendment giving Congress the power to put in place an income tax. And then we have the 27th Amendment that says if Congress votes itself a pay raise, the pay raise doesn't take effect until after the next election, basically to give the voters an opportunity to weigh in on whether or not those members of Congress made the right decision. And then we had this brief experiment in the US. In 1919, the 18th Amendment put in place prohibition and allowed Congress to prohibit the manufacture, transportation, and sale of alcohol. But that amendment was repealed in 1933 with the 21st Amendment. So I know that's kind of a whirlwind of all these different amendments, but keep in mind, there's only 27 of them. And actually there's been over 11,000, now closing in on 12,000 amendments that have been proposed in Congress that have not gone on to the states, that have not been ratified. And so it's much easier to come up with an amendment than it is to actually get it ratified and to get it approved both at the national level as well as by 3/4 of the states. So that's the text of the Constitution. But in addition to the text, we have the interpretation of that text by the US Supreme Court. And because going all the way back to this case known as Marbury versus Madison in 1803, the Supreme Court has the power of judicial review, the power to say what the Constitution means and to say if the Constitution is being adhered to properly or not. We have various areas of decisions that interpret what those rights are and what those powers are under the Constitution. And so the US Supreme Court really has this authoritative power to tell us what the Constitution means. So it's important to look at some of these different areas that the court has decided over the years. And sometimes the court has reversed course. The court used to adhere to this idea that the Constitution protected what they called the liberty of contract. It was going back to the late 19th century, this case Allgaier versus Louisiana. The Supreme Court says that even though the Constitution doesn't say liberty of contract anywhere in it, that this was something the court said was protected and limited the ability of both the federal government and the states to be able to impose different types of economic regulations. An example of that, maybe the best example of that, was a case called Lochner versus New York, where the Supreme Court says that a law putting in place maximum hours for bakers in the state of New York was unconstitutional because it infringed on the ability of the bakers to freely contract with their employers over what the terms of their employment would be. The state of New York had passed that law to try and protect bakers from being overworked, to protect consumers from the products of overworked bakers, but the Supreme Court said that was unconstitutional, violated this liberty of contract. Well, lo and behold, by the time the Great Depression comes along, we have this revolution on the Supreme Court, where in 1937, the Supreme Court ends this idea of the liberty of contract and says the Constitution, in fact, gives both Congress and the states more power to regulate the economy. This began in this Jones and Laughlin case, where the court said that Congress could regulate labor relations, but it also continued that same year in West Coast Hotel versus Parrish, where the Supreme Court upholds the authority of states to set minimum wage laws. And so beginning in 1937, you have the Supreme Court approving a lot of these regulations of the economy, from minimum wage laws and things like time and a half pay, through various other types of labor regulations and consumer protection laws that Congress and the states have since passed. Another key area of court decisions has been on the question of racial equality. Where we see, beginning in Brown versus Board of Education, the U.S. Supreme Court says that public schools cannot be segregated based on race. Heart of Atlanta Motel, the court says that Congress has the power to be able to ban segregation in public accommodations. In other words, businesses open to the public, such as, in this case, hotels, but also restaurants and movie theaters, and again, other businesses that are open to the general public. And then more recently in Grutter versus Bollinger, which is the Supreme Court upholding past decisions saying that public universities may consider race in their affirmative action programs and admissions. Now, the question of race was clearly on the mind of those who wrote the 14th Amendment, given the context at the time. The US Supreme Court has over time said that there are other forms of discrimination that are also prohibited by the 14th Amendment and its Equal Protection Clause. Reed versus Reed, the court says the 14th Amendment also bans sex discrimination. And more recently in Obergefell versus Hodges, the court said that the 14th Amendment protects the right to same-sex marriage. In other words, states cannot ban same-sex marriage in the US under the 14th Amendment. We also have the right to privacy. That is not something that's in the Constitution in any direct way. The word privacy isn't in there. But beginning in Griswold versus Connecticut, the US Supreme Court has said that there is a right to privacy that's protected by the Constitution. In a very famous decision, Roe versus Wade, the Supreme Court said that the right to an abortion is protected by the Constitution's protection of privacy. And in Lawrence versus Texas, the Supreme Court said that adults engaging in consensual, intimate activities in the home are also protected from government interference by this constitutional right to privacy. Some examples of the rights of the accused and things that are elaborations by the court on what the text of these different amendments in the Bill of Rights say. Supreme Court in Mapp versus Ohio said that if evidence is gathered illegally, it's excluded from use at trial in a criminal case. And so that means that if the police engage in an illegal search, that evidence cannot be used in a criminal trial against that defendant. We have Gideon versus Wainwright, which elaborates on this right to an attorney in a criminal case, saying that if a defendant is too poor to afford their own attorney, one should be provided for them by the government at the government's expense. And another very famous case in the US, Miranda versus Arizona, which said that if a criminal suspect is being interrogated in police custody, they have to be warned that they have the right to remain silent and that they have the right to an attorney. And so that, people therefore have the right to be informed of what those rights are so they can exercise them in an appropriate way. And then finally, kind of round out some of these key court decisions. We have various US Supreme Court decisions on First Amendment rights. So freedom of religion, freedom of speech, freedom of the press. Some of these major examples. One is Engel versus Vitale, saying that the government cannot have a prayer that it sponsors in public schools. That violates the freedom of religion protected by the First Amendment. Brandenburg versus Ohio, very important free speech decision, saying that even if one advocates violence, that's protected unless one's expression would incite imminent lawless action. So if one is, for instance, advocating, there's a lot of famous cases in the 19 teens through the 1950s and into the 1960s, people advocating for communism and being criminally prosecuted for that. Supreme Court says you can advocate for even the overthrow of the government up to the point where your speech would be inciting imminent lawless action. In other words, lawless action that would occur in the very immediate future, kind of organizing, conspiring to do something. That's not protected speech, but anything up to that point is. New York Times versus the United States is a very important case elaborating on the freedom of the press, saying that as a general rule, the government can't stop the press from publishing something beforehand. They can't engage in what's called a prior restraint of the press. Texas versus Johnson says that the burning of the American flag is protected by the First Amendment. Employment Division versus Smith tells us that even burdens on religious exercise by the government will typically be upheld as long as those regulations by the government are neutral and are generally applicable. And if we want to get into more detail what that means in the question and answer period, we can certainly do that. And then finally, there is one of the court's more famous, more recent decisions here in the 21st century called Citizens United versus Federal Election Commission, stating that corporations have First Amendment rights to be able to engage in campaign expenditures for candidates for political office, to basically be able to put out advertisements or to speak through these type of expenditures, that's protected by the First Amendment. So again, I know that's a lot of cases to talk about here and a lot of amendments, but we can certainly dive into any of these in more detail here in the questions as we go along. So I'll turn it over for questions at this point.
Okay, great. Eric, can you get it back to you?
Yes.
The share screen. Okay, well, thank you so much, Professor Casper. That was quite a magistral tour through this very important period of US history. So as you can imagine, there's a lot of questions already that people have raised. So unfortunately, we can't answer all of the questions individually, but what we are going to do is to try to answer those questions that have been asked over and over again, or questions that illustrate maybe the larger point of your lecture. So let me just start with the first one that has been asked a couple of different times. And that is some of the students wondering about the relationship between Declaration of Independence and the Constitution. They noted that you don't say much about Declaration of Independence. What's the connection between those two documents?
Yeah, the Declaration of Independence is a very interesting document, a very important document for US history and for the founding of the country. In that it does, as the title suggests, I mean, it declares independence. It's in of itself, though, it's not it has no legal standing, so to speak. I think there's some important connections between the Declaration of Independence and the Constitution, as far as, a document that rallies people to the cause of the American Revolution, a document that demonstrates through its popularity some of the things that should not be a part of the US government under first the Articles of Confederation and then the US Constitution. That, you know, we didn't want, for instance, a monarchy. We didn't want a legislative setup specifically that looked like the British Parliament. I think that's something that is a connection between the two documents. And even some of the key language that we see in one part in particular, where the Declaration of Independence talks about you know, the need to rally to the cause of revolution to protect life, liberty, and pursuit of happiness. We see some similar phraseology in the Fifth Amendment and later the 14th Amendment, talking about the need to protect life, liberty, and property, and that if those things are to be taken away, it has to follow a due process of law. So there's definitely some of those connections there. And I think even the political philosophy outlined in the Declaration of Independence, where Thomas Jefferson is, as he's drafting it, really focuses a lot on John Locke's Second Treatise of Government in terms of political philosophy that's expressed there. We see that in the adoption of the US Constitution as well, not only in terms of the structure of government, but the ability of the people to say that they have the right to alter or abolish a system of government, with in our cause with the Constitution altering what was in place under the Articles of Confederation.
Thank you very much, Professor Casper. So you can see our participants are really engaged. We're getting lots of different questions. Let me say another thing, which is that we will share your questions with Professor Casper, and we have asked if he could suggest some further reading and you know, online resources. So seeing your questions will help him figure out what would be the best in terms of some of that reading material. So that's another way that you know, your questions could be addressed. So I think another set of questions that have arisen have to do with the question of racial equality, racism, slavery. And so essentially, if you could say a bit about what was the role of slavery in the Constitution, and how the interpretation of the Constitution over the years have helped in terms of granting equality to African Americans particularly.
Yeah, that is, as I mentioned earlier, I mean, that is one of the ways it's been characterized as, you know, one of the original sin of the American experience. That here we have both the Declaration of Independence and in the Constitution, this focus on the concept of liberty. Even the Declaration of Independence talking about how, you know, all persons are born equal. And yet here we have this institution of slavery, which remains legal in a number of states for decades later. I think, you know, at the Constitutional Convention, there certainly were delegates who, I mean, they were enslavers at the Constitutional Convention, and those who supported slavery, as well as those who were indifferent or maybe agnostic on the question of slavery. And there were also delegates at the convention who were abolitionists. This was another one of these cases where they could not reach a consensus on that question. And if they had tried to say that, you know, slavery would be abolished, or if slavery would be legal in every state, or permitted in every state, or would be required in every state, those would be things that would not have allowed for any document to come out of that convention or to be ratified. And so what they did is they have this uneasy set of compromises on slavery, to say that, as I mentioned earlier, the 3/5 compromise, but also the ability to ban the importation of enslaved persons, that Congress didn't have the power to do that for the first 2 decades under the Constitution. Another one of these compromises built in. And so this question isn't resolved until generations later, during the American Civil War and ultimately the 13th Amendment. But even the post-Civil War amendments, they put on paper that we're supposed to have racial equality. But that does not go into effect in various ways for a very long time. Not until you have other amendments or court decisions, laws that are passed, civil rights laws that are passed do you start to see this furthering of those goals that were really stated forthrightly in the 13th, 14th, and 15th Amendments? And you know, some of that doesn't pass Congress in any meaningful way until a century later, or they're not court decisions until a century later. And even today, I mean, there are really these questions that are raised when it comes to questions of the enforcement of voting rights based on race, when it comes to questions of mass incarceration and the criminal justice system and racial equality there. And so, you know, these are still a part of the American experience, this question of what can we do to better live up to the goals stated in the Constitution? Because at the end of the day, the Constitution tells us what we're supposed to do. Whether or not that happens is reliant on these institutions of government and ultimately what the public itself is able to do to see if we're going to live up to that potential, that language that's listed in the Constitution.
Thank you very much. It is a complicated question, and some of the other presenters will also be addressing. We're going to have a whole lecture devoted to civil rights movement, and so I think that this is a persistent question in American politics and history, and it will be addressed in other places. Okay, so another set of questions are about particularly the role of the judiciary, the issue of judicial review, and so in general, how powerful have the interpretation of the judiciary been in really making this document a living document? So what is the role of judiciary in elaborating the Constitution?
Yeah, the whole idea of judicial review is, it's certainly implied by the text of Article 3 of the Constitution, but it was not a settled question until the Marbury versus Madison decision in 1803, where the Supreme Court basically seizes this power of judicial review and says, we have the authoritative power to interpret what the Constitution means. And as I noted, you know, and I really just gave a sampling, but you know, probably 30% of my slides were about U.S. Supreme Court decisions interpreting the Constitution, and you know, questions about the desecration of the American flag being protected by the First Amendment, the banning of government-sponsored prayer in public schools, the banning of government-imposed racial segregation in public schools. The Constitution doesn't say any of these things specifically. These are the result of U.S. Supreme Court decisions. And so a lot of what the U.S. Constitution means and how it's enforced ultimately comes down to these different court decisions. That being said, I mean, there is a major difference within both the legal community as well as more popularly politically between those who believe that we should be focused on a more originalist interpretation of the Constitution and, in other words, look at what the Constitution meant at the time that it was written versus those who would take a more what is sometimes a more politically progressive approach of a living Constitution understanding, which is to say that the Constitution needs to change in terms of how we interpret it based on how society has changed. And again, we see examples of that from the power of what the government can do in terms of economic regulation, where we've seen the court change course on that, as well as in a whole host of individual rights and freedoms, where the court has offered an interpretation that is authoritative, but may not have been what the people who wrote that and put it into effect much earlier in time, what they intended. But again, we have different philosophies on the Supreme Court about how to interpret that language.
Thank you very much. Another set of questions I think have to do with the idea of democracy and how that's lived through in Constitution. So the world over, US Constitution is seen as a very democratic document, especially Bill of Rights is something that has, celebrated as a way to give people liberties and freedom. So some of the questions have to do with why that democratic documents seem to be failing in certain instances. Why is democracy not as robust in areas where it could be? There are others who are asking more specifically, given your earlier comment, that the founders were somewhat skeptical of democracy. So if you could say this relationship between democracy, how it was understood perhaps at that time versus how we understand it now, and what's been the role of Constitution in both expanding and constraining democracy as we variously understand it.
Yeah. Well, yeah, I mean, the founding generation, they certainly wanted to have a representative republic. But many of the members of that generation, particularly those who were the leaders of the movement for a new constitution, many of them had concerns if you have too much democracy, it basically would devolve into a type of mob rule, is the way many of them thought. And so that's why we have only the one part of the federal government that's directly elected, members of the US House of Representatives. Senators were appointed by state legislatures. The president was indirectly elected by the Electoral College. Certainly federal judges, including US Supreme Court justices, they're appointed by the president and confirmed by the Senate. They have no direct connection to the voting public. And even the right to vote was very much constrained. If you go back to the 1780s, it was basically limited during that period to white men who had a certain amount of landed property. Now, what we see over time is somewhat of a democratization of the US Constitution. In other words, the right to vote is first extended so that one doesn't have to own property in order to vote, and then it's extended so it cannot be denied based on race or on sex. The right to vote is lowered to 18. So you have the voting populace, which is significantly expanded. And then, because of other reforms, we have, in particular, the direct election of U.S. senators. So the senators are more responsive to the public than they would have been at the nation's founding. But there are all these questions that still remain. Are we democratic enough under our system? That right to vote and how that is carried out is still a significant question in terms of how much are voting rights enforced. Who has the right to vote denied to them? For instance, persons who have been convicted of felonies, to what extent can they be denied the right to vote? And that varies from state to state. There are questions about how many polling places are open in each area. And so if people have to wait a long period of time in line to vote, does that deter the right to vote? So you have all of these questions that are there in terms of the connection between the voters and public officials in terms of the right to vote. How is that being protected? But you also have questions about gerrymandering. And so are legislative districts skewed too much by the party in power to promote their political party? And that is a question as recently as last year that the US Supreme Court has said the Constitution really leaves up to state legislatures and to Congress to be able to fix the problems of gerrymandering. And so that's an area where the courts have they basically in recent years said that it's not something that they have the authority to do anything about. They're basically leaving it up to public officials. And so we still have these questions about the ability of the people when they vote to translate those votes into public policy through their elected officials. Again, I think the US Constitution has had a series of reforms that have made it more democratic than it was at the time of the founding. But like a lot of other areas of the US Constitution, we can still look at it today and ask, does it need to still be reformed compared to where it is right now?
Okay, thank you very much for that. So another question that I think is particularly interesting for Pakistani audience is the role of military in the Constitution. Can you say something about what is the role of military in the US Constitution?
Yeah, when it comes to this question of the control of the military and military affairs, there's actually a division of power between Congress and the president. Although especially in more recent decades, through different acts of Congress and through presidential action, and particularly during the nuclear age, the president, in a de facto sense, has gained more authority in this relationship between the two branches. But if you look at the Constitution itself, it says that the power to declare war is a decision to be made by Congress. The ability to fund and to regulate the military, that belongs to Congress. The Senate has the power to be able to ratify any treaties that are negotiated by the president. And so you have various powers that belong to Congress. But at the same time, the president is the commander-in-chief of the military. And that carries with it quite a large amount of power. I think the theory at the time of the founding was that Congress would assemble and the legislative representatives would determine if the country needed to go to war, and if they voted to declare war, then for efficiency purposes, the questions of how the war would be conducted would be turned over to one person, the president. However, the way that war has evolved since the late 18th century has meant that a lot of US military operations are much more targeted than the mobilization of the entire country's military forces to be stationed somewhere in particular on US soil and to fight a war on US soil. Most of that fighting occurs overseas. And so the president's ability to act quickly as commander-in-chief is something that has come much more so into the fore, particularly in the post-World War II period. And even through acts of Congress, like the War Powers Resolution of 1973, Congress basically cedes that authority to the president to be able to engage in military operations abroad for up to 90 days. Now, it's a power Congress could, in theory, take back, but it has chosen not to do so. And even if Congress did take the War Powers Resolution off the table, presidents themselves in more recent decades have said that their Article 2 power as commander-in-chief would give them the authority to do that anyway. And military affairs like that is also an area where the Supreme Court is very afraid to tread because of their lack of expertise in foreign affairs and military affairs. So a dispute between Congress and the president over the war powers could potentially, under the wrong circumstances, could really create a recipe for a constitutional crisis. Again, in recent decades, because of changes to how wars are conducted, that balance between Congress and the president has more so shifted to the presidency in terms of how and when war will be conducted, especially if it's going to be done in a targeted fashion over a relatively short period of time. Over a longer period of time, Congress could cut off funding or could do some of the things that it ultimately did during the later stages of the Vietnam War.
Okay, thank you very much. I think you're doing such a wonderful job of addressing these very complicated issues. So another one, again, from this is particularly something that Pakistanis are also very interested in, and that's the concept of federalism, the relationship between federal government and states, as they're known in the United States, or as provinces, we say in Pakistan. But anyway, how has the Constitution played a role in working out this relationship between the federal government and the states in the United States?
Yeah, the American system of federalism has, in some ways, there's a lack of clarity that's always been there. What is fully a federal power versus a state power? In some areas, this is clear. As topic that we just discussed, the power over the military and foreign affairs. Definitely clarity there that belongs to the national government. there are some powers that are concurrent powers. It can be exercised by both levels of government. And the power to tax is certainly one of those. Each level of government wants its opportunity to be able to impose taxes, because each level of government has to pay for what it does. But then we have this, in some cases, uneasy tension. Where's the line between federal power and state power? And there's also a whole host of Supreme Court cases interpreting where that line is. But that line has moved over time as well. At the time of the founding, there was more power that was lodged at the state level than when we look at that comparative relationship today. The kind of one of those key moments was that Civil War period and those few years after the Civil War. That 13th, 14th, and 15th Amendment took away the powers of states to be able to legalize slavery, to be able to deny the vote to people based on their race, to be able to deny people certain rights that the Bill of Rights said the federal government could not. The 13th, 14th, and 15th Amendment, when they were ratified, as well as how they've been interpreted by the Supreme Court, have over time shifted power away from the states. In some ways have empowered the federal government more. Under the 14th and 15th, and even in the 13th Amendment, for instance, Congress has the power to pass legislation to enforce the rights in those amendments. And so those amendments after the Civil War, in one short period of time, took a number of powers away from the states and even gave some new powers to the federal government. And again, even in more recent years, these questions have come up. The question of Obergefell versus Hodges, the same-sex marriage case as an example, where that was a question about, did states have the power to define marriage as they saw fit, or did the 14th Amendment say that the fundamental right to marriage has to be applied on an equitable basis to both opposite-sex couples and same-sex couples? And so even in a lot of these questions about civil liberties and civil rights, it raises questions of federalism. And these are, again, questions that are ongoing, that the Supreme Court has to decide when they arise. And again, as I said, there's always been a tension, there's always been a disagreement in going back to the founding period. How many powers should be at the state level? How many powers should be at the national level? That's an ongoing conversation that we continue to have. It's a conversation that divided Thomas Jefferson and Alexander Hamilton, and they disagreed very strongly in the 1780s and the 1790s over how much power should the states have versus the federal government. And we remain as a country engaged in that debate all these decades later.
Okay, thank you very much. Another set of questions I think have to do with the Civil War, and you've addressed some of that already, but just Civil War and how that changed, or if it changed the Constitution, the role of Constitution in American society, American politics.
Yeah, most definitely. I think the Civil War itself, it's ultimately a question about the state powers and how much power states have over various issues. The key issue, obviously at the time, was in terms of state power, was that of slavery. And the 13th Amendment resolves that question in a certain way, but the 14th Amendment becomes very important as well, because the 14th Amendment defines citizenship, because the Supreme Court decision shortly before the Civil War, Dred Scott versus Sanford, had defined citizenship in a way that Scott, as someone who was enslaved, couldn't be eligible for citizenship under the US Constitution. So the 14th Amendment says, yeah, if you're born or naturalized in the United States, you're a citizen, and you carry with you then all of the rights and privileges that attach to citizenship. So the 14th Amendment then greatly restricts how states can define citizenship in their own right by just the text of the 14th Amendment and an authority that states otherwise were exercising before the Civil War. But then again, with the Civil War itself and those post-Civil War amendments, putting at least in the Constitution the right to equal protection of the law, protection of voting rights, the abolition of slavery. And again, the question of have we always lived up to that text is another question. But we've been moving in the direction in a lot of significant ways towards fully realizing what those post-Civil War amendments do. The Civil War as a moment of constitutional change is very significant for that reason, not just the war itself, but the amendments that were spurred on by the war. Really, if you were to look at the three different key moments for the US Constitution, one is at the period of the founding, the Constitutional Convention, the Constitution's ratification, and then the Bill of Rights, all coming in a short period of just a few years from 1787 to 1791. The second key moment is the Civil War itself, and then the post-Civil War amendments between 1865 and 1870. And then really the third major moment becomes that point during the Great Depression in 1937, really until 1942, where we see the Supreme Court really change course on the regulatory power of the government over the economy, which has really changed the shape of the American economy and what it looks like in the several decades since. That these are kind of these three main moments where we've seen this very large-scale constitutional change. You might also throw in there, I think, that the Supreme Court in the 1960s during the Warren Court, where they are issuing decisions not only promoting civil rights, but also protecting the rights of the criminally accused and protecting First Amendment freedoms. There's kind of this moment there as well where we have a realization in various court decisions of those post-Civil War amendments too. But we can't have that moment if we don't have that change of course at the end of the Civil War.
Okay, thank you very much. I think another sort of set of questions that have to do, and this was asking you to sort of reflect, I think, on somewhat on sort of looking back to from the beginning of the Constitution. The question has to do with what role did the Constitution play in making U.S. a rich, prosperous, and even a superpower in the world?
Yeah, I think that was, besides the big event of Shays' rebellion, and besides questions about some other efficiencies of government, you really have the major concerns that existed at the time being those of international affairs and those of the development of the U.S. economy. And the Constitution really changes course from the path the country was on under the Articles of Confederation. That the hindrances to the development of a fully operating, integrated national economy in terms of states issuing their own currency, in terms of states being able to erect trade barriers against products and businesses from other states, that was really hindering that development economically. And so under the Articles of Confederation, if the country had continued on that course, our economy might look very different today. And the ability then to have that wealth and to be able to do things with it may have been greatly impeded. And at the same time, this question of international affairs, that under the Articles of Confederation, the ability to really enforce U.S. treaties was left to the states. The federal government had very little ability to actually enforce those treaties. Federal government, because it didn't have its own independent taxing authority, as a question of, could you maintain a robust military under the system created by the Articles of Confederation? So, U.S. foreign affairs, I think, would look very different today under a continued Articles of Confederation system. So I would say that, the development of the U.S. Constitution really has a major impact in that regard. Now, we don't see that in its full force until the 20th century in terms of the U.S. Taking that type of action or having that type of influence on a global scale. But even in the 19th century, things like the Monroe Doctrine and other spheres of influence that the U.S. has in the Western Hemisphere, those are things that would have looked, I think, very different if we were operating under the Articles of Confederation.
Okay, thank you very much. So I think another sort of point of interest for our audience has to do with the fact that the US Constitution is a very brief document. Compared to Pakistan, for example, one of the questions is in Pakistan, they have put in a lot of things, how to select judges, etc. There are a lot more, and you can see that in some other countries too, that the constitutions have actually been more extensive. Sometimes they have included particular policies, for example, gender equality, what have you. So the questioner was wondering if the brevity of the Constitution is actually one of its deficit or deficiency, or is it something that actually has been kind of effective in terms of how history has worked it out?
Yeah, exactly right in terms of the shortness of that document. And even compared to US state constitutions, the US Constitution is relatively brief. Most state constitutions in the US are significantly longer, in some cases 10 times as long as the US Constitution in terms of their length, in terms of the number of words in the document. So on the one hand, I mean, this is something that very famous Chief Justice of the United States, John Marshall, got to in one of his early court decisions, where he talks about, the Constitution is written in language that allows it to be adapted to the various crises of human affairs, right? Meaning that the language is, it's open to more interpretation because it's shorter. And that is one of the reasons we could look to and say, well, perhaps that's why it's lasted as long as it has, because it doesn't box the country in too much in a moment of crisis or emergency, or new generations can look at it and find new meaning in the same text if it's relatively brief and if it's written in these broad terms like the freedom of speech or equal protection of the law, things like that. Now, one of the things that comes hand in hand with that is that the Constitution is relatively difficult to amend. And so if you had a Constitution that was much more specific and it was still difficult to amend, then that would make for a system that would be much more problematic in terms of its functionality. Because if it's very specific and you can't amend it very easily, then it does kind of box you in. The U.S. Constitution is written in these briefer terms, but it's also difficult to amend. So, it maybe in that respect promotes it being subject to newer interpretations. The other thing that does is that it's one of the reasons why the U.S. Supreme Court is as influential over the American experience as it is. Because if it's hard to change that text, and if the text is short enough to be subject to varying interpretations, that gives the court with the authority to authoritatively at least interpret it, the power to be able to determine what the Constitution means to a much greater degree. Because at the end of the day, if the public doesn't like how the Supreme Court interprets the Constitution, we have the ability to amend it. And that's happened several times over American history, where an amendment was begun and ultimately was ratified in response to the Supreme Court's interpretation of the Constitution. But at the end of the day, because the Constitution is difficult to amend, it means that on most issues and on most of their decisions, we are going to have to live with the Supreme Court's interpretation of that language.
Okay, thank you very much again. So I think we're coming down to, we have maybe another 7 minutes or so. So we will handle a couple of other questions. Thank you for your patience and stamina, Professor Casper. So I think another set of questions are related to what we might call a war against terror, the Patriot Act, and the role of Pentagon, etc. So in terms of the constitutional protection of citizens' liberties, Has there been a kind of erosion of that? Is there a tension between what has happened since post 9/11 in terms of civil rights and liberties and the need for security, if you want to put it that way?
Sure, and I think as with a lot of questions we've looked at so far, the answer is, maybe kind of one of these all of the above types of answers, where we've seen Supreme Court decisions going back historically, particularly since the 1950s, saying that when it comes to these questions of war and when looking at the war on terrorism in particular, that the president's powers are bolstered if the president has the official support of Congress. If Congress passes a declaration of war, if Congress passes a resolution like the authorization for the use of military force after 9/11, that's going to bolster the president's power because the president is working in conjunction with Congress when it comes to these types of questions of threats to US security. But Supreme Court has also said that's not a blank check. And so we do see decisions coming down after 9/11 where the Supreme Court has said that the federal government in some cases has overstepped its authority. One of the biggest cases in that regard was the Hamdi decision, Hamdi versus Rumsfeld, where you had someone who was who came into US military custody, who was determined by military officials to be an enemy combatant and was being held under indefinite detention. And the US Supreme Court said that simply because a US official from the Department of Defense says someone is an enemy combatant, particularly if that person is a US citizen, that person cannot simply be held without trial or without charge. At a bare minimum, a military commission would have to be convened in order to determine if someone who claims that they're not an enemy combatant actually is or isn't an enemy combatant. And so we have some limits in that regard when it comes to actually people who are taken into US military custody. We also see, though, these questions under the US Constitution domestically in terms of Fourth Amendment search and seizure and in terms of the right to a criminal trial. And we're seeing, at least in those decisions, not much relevant case law on those domestic questions as of yet, although they were seeing precedents from the Supreme Court, particularly with the use of technology over the last 2 decades, where the court has put up somewhat of a stop sign to the federal government if they are going to be using things like different types of technology, including GPS tracking or these sorts of things, that the safest course for the government, if it wants to see those types of searches upheld and evidence from them to be able to be used in court, they need to get a warrant or they need to fit some sort of well-recognized exception under the Fourth Amendment to the warrant requirement. And so again, I think that's like everything else, the American public is divided on how much authority should be exercised here versus the protection of civil liberties. And we see justices on the Supreme Court divided on that question as well. We've seen different approaches by different presidents over the last 3 decades on those questions. And so we have somewhat of, I don't know, mixed is the right word, but some different decisions kind of pointing us in different directions sometimes, depending on the subject matter from the US Supreme Court.
Again, thank you very much. A complicated question, but you have addressed some of the key elements. So I'm going to give you a very simple last question. This is our last question, and that has to do with the role that US Constitution has played in protecting religious liberties and freedoms in United States. So what's the relationship between religion and the Constitution, or particularly religious liberties, because famously we know about separation of church and state in the US.
Yeah, and this mainly stems from the First Amendment to the US Constitution, which has the Establishment Clause, as well as a free exercise clause. So I mean, the First Amendment begins by stating that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. That's another one of these parts of the document, though, that is written in relatively brief language. I mean, there's a prohibition on religious tests in the original Constitution for one being a public official or taking public office. But otherwise, the Constitution's statements, direct statements on religious freedom, are relatively brief. And so we have a host of Supreme Court decisions interpreting what those rights are. And really, these two different parts of the freedom of religion under the U.S. Constitution, that there's the free exercise clause, which says that you're free to believe as you wish in terms of religion, although there are limits that the government can put on that if you start to take action based on those beliefs. And then we have this disestablishment requirement that we cannot have an official religion that's established by the federal government. And beyond that, we've had justices who have disagreed. How much does that disestablishment require? Although the school prayer decisions that I talked about earlier, those were key decisions interpreting the Establishment Clause of the First Amendment. And that's certainly been an enduring part of the American experience. Part of the American founding was, and the American colonies was about people coming to the United States to exercise their religious freedom, although some of those same colonies early on established their own official religions. And so that's one of the reasons why the First Amendment becomes necessary, and why the US Supreme Court's interpretation of that amendment has become so important to ensure that we don't have an official religion. People are free to choose the religion they want to practice or to not practice any religion at all.
Again, thank you so much. I think that sort of concludes our Q&A session. Again, I think we have tried to address most of the questions that were asked, but we will recommend some readings. And also, I think Professor Casper has set us up very well for other lectures because some of these themes will keep coming back. And so, Eric, may I call you Eric? Thank you very much. Really appreciate the time that you've given us and the clarity with which you have addressed these very complex questions. I want to thank all of our participants, and I hope to see all of you next week. July 7th, I think, is our next presentation. So thank you very much. This concludes this session.